It's our choices that show who we truly are, far more than our abilities. Among all the choices, you are the one who have chosen to learn, which is priceless. A very good evening to all of you. I am Prabhava Hegde, member of Indirect Tax Committee of Karnataka State Chartered Accountants Association and your MC for the day. We are here to hone our skills, and it's my pleasure to welcome each and every one of you listening to this webinar. As we all know, along with all the features, GST is also an ever-changing law. There are countless changes happening every day by either administrative or judicial means. Today, we are here to gain some light on the changes from the judicial point of view, which is also the most wanted topic, recent decisions in GST by Honorable High Courts and Supreme Court. During its early days, KCIA had created a professional development fund to support development activities relating to profession. Many CAs and CA firms have contributed towards this fund. Today's webinar is in the name of late CA NCS Raghavan. It's also our pleasure that CA Ashok Raghavan sir is also with us. I will hand over the mic to our respectable Ashok Raghavan sir for a few words on this occasion.
Thanks for the introduction, Prabhava Hegde. Good afternoon, the members of the KSCA, and Chandrasekhar Shetty had called me yesterday and asked me to just come on air for a few minutes to kick off this webinar today, being addressed by a good friend of mine, very learned, eminent, excellent, and authority on the subject of GST and indirect taxes, and authority on almost everything which he talks about, Mr. V. Raghuraman. And it's a very topical webinar today because GST, as you have rightly put, is being a nascent legislation, is bound to go through a lot of judicial interpretational challenges. No better than Mr. Raghuraman to take up the session today and enlighten the members of KSCA. I'm happy that this particular webinar is in the name of my late father, NCS Raghavan. As you are all aware, was the past president of the KSCA maybe 25 years back. I fondly remember the organization because that time I was doing my articleship, and to conduct seminars and workshops, they used to tell us to go to the manual printing press and do proofreading throughout the night so that the brochure comes out well in time. And my father used to dictate 200, 300 pages, and in handwriting we used to write it and go and change and give it back because there was no computers, there was no all these latest technology which we have, where a lot of cut and paste is going on. So we honed our skills because of the pre-computer days, to be very frank. But KSCA was very dear to him, and he built the organization like many past presidents and like all of y'all are doing today. And it's dear to me in that sense that I contributed my bit as a student. And later on, when my father was president, almost the whole year I spent time with him in organizing seminars, workshops, etc. My father firmly believed that knowledge kept in the cupboard is as useless as the wood which is used to make that cupboard. Unless knowledge is disseminated to the people who require it, knowledge is absolutely useless. So with that motto, he used to, once in 3 years, 4 years, he used to program or conduct workshops of week, 10 days on various subjects and ensure that the members are updated. And believe me or not, on the 3 days before he passed away, when he was taken the next day morning to hospital, I went and saw his desk where he used to sit and write. And he was writing an article on GST on real estate. And he used to write everything in his own handwriting. When people came to see, pay respects to him when he was kept in my house, I showed most of the chartered accountants that particular piece of paper which he was writing at 1:30 in the night, when apparently he fell, and from that time he never came back. So I showed it to a good friend of mine, Venkatramani, who is another learned author on GST, and he was shocked that at the age of 85, my father was still learning on GST on real estate and writing it himself from the basics. So that's the way he was, and I'm again happy to be part of this. To give this, I won't call it a keynote address because in front of Mr. Raghuraman, we can't address anything because I'm sure he will have everything in his arsenal. So I thank again the KSA and for doing us this particular webinar in memory of my late father. And again, as I repeat, no better person than my good friend and learned author Raghuraman to take the session today. All the best. I think okay, guys can carry on. All the best, Raghuraman.
Thanks a lot, sir. That was a good kickstart to our session. Moving on to today's speaker, it gives me immense pleasure to welcome a fine dignitary in the field of indirect taxation, who is none other than V. Raghuraman sir from Bangalore. He is a FCA, ACS, BCom, LLB, and graduate in CWA. He is a rank holder all through his academic courses. His achievements are first rank in BCom, 38th rank in CA Inter, 24th rank in CA Final, second rank in ICWA, and 25th rank in ICWA Final. He is practicing as an advocate and CA from past 30 years. His specialization is in the fields of GST, excise, customs, service tax, foreign trade policy, and FEMA. He also specializes in indirect tax planning and litigation, and he frequently appears before various courts. He is also a visiting faculty in the Indian Institute of Management, Bengaluru, and the CA Institute. He has addressed a large number of seminars and published several papers in national magazines on GST, excise, customs, service tax, FEMA, and he was also a member of the Indirect Tax Committee of the ICAI, New Delhi during 2014-15. He has also authored well-known books, few of which are GST and Indirect Tax Principles Demystified, published by International Publishing House, CCH. Central Excise Law and Procedures, published by R.K. Jain, New Delhi, who is the largest producer on indirect taxes. Background material for e-learning course on service tax and technical guide to SENVAT, published by ICAI. Sir, we are truly blessed to have such a majestic personality in this program, and we also seek to have your association with KSCAA in the years to come. We request viewers to please enter your queries in the question and answer box made available on the screen. It will be on your right hand side of the screen. Relevant queries will be taken up for discussion by our speaker towards end of this webinar. Now I request Raghuraman sir to please take over. Over to you, sir.
I thank the KSCA for inviting me, and in particular, I have to thank. I'm very happy to see Mr. Ashok Raghavan. He is such a widely sought after speaker, especially on aspects of real estate. Even up to Calcutta, people will ask for Mr. Ashok Raghavan. And I remember his dad also very well, because for KSCA, I remember he asked me to write an article. This is, I'm saying, in somewhere in early 90s when I had just started my practice. So he was a kind of a person who was very keen on furthering the chartered accountancy profession, whether it a youngster who was just enrolled or it was an elderly person who was practicing for several years. So that family, the interest that they show in the profession now is being carried forward by Mr. Ashok Raghavan, a very good friend of mine. And, I just hope that their family will carry this forward even more, with more CAs in their family, because that is how, some people are, born to be helpful to others. I think Raghavan family is born to be helpful to others. So with these few words, I will go into my topic for the day, which is, of course, the recent decisions of the Supreme Court and High Court in GST. While GST itself is recent, as per all standards, it's only 3 years old. When you compare the other laws are, like donkeys years old of 30, 40, 50, 100 years. GST is only what doing. I will be trying to present you all the important decisions that have come in the last 3 years. That will give you a good backdrop of all the, when I say talk of decisions, I will try my best to concentrate only on those which are final decisions. Decision means anything that disposes of the matter completely with a reason. I don't want to talk on interim orders and other orders unless they are very important and which can be brought to my notice by the viewers for comments. So let us start with, I have divided this topic into several chapters. What I plan to do is that up to around 5:45 or a little more, 5:50 maybe, I'll try to give you a gist of all the decisions that are there which have been passed in the last several years, and I'll concentrate a little more on the last few decisions that have come in the last few months. That will give you more emphasis. After that, I will take the question answer sessions. After about an hour and a half, roughly, I will be taking the question answer sessions. So first we will look at what are the challenges to the validity of the provisions. Because when you go to High Court or Supreme Court, we must remember one thing. There is a substantial difference between appearance in the High Courts and Supreme Courts and appearance before other authorities. The difference is this. The learned judges who are sitting on the bench may not be fully conversant with GST in all its nuances as many of the chartered accountants who are here present. But their concept of law, their understanding of law, their understanding of several legislations across several fields, and the amount of material that these judges have read, because the lawyers from different fields keep giving them different material, makes them highly learned in the field in which they are. So when we go before these learned judges, we must talk the law. This is the first thing which we should remember. When we talk of the law, I'm not saying you're talking of circulars. I'm saying talk of the act, talk of the rules, talk of the notifications, and then last in this hierarchy are the so-called circulars. Because when you look at the practice before High Courts or Supreme Courts, they're interested in what the law states, what the legislature has stated. Please understand, the state has three organs. There is the legislature, executive, and the judiciary. Judiciary is an organ of the state. And therefore, the High Courts and Supreme Court being constitutional courts are interested with interpreting the law as it stands and as is made by the legislature. So therefore, the respect that they give to the act is much more than the respect that they will give to the rules, because rules are subordinate to the act. Rules are made by the executive, which can always be controlled by the legislature. Notifications which are issued are also a category of subordinate legislation, and therefore the respect that is given to notifications and rules is much less than the respect that they give to the legislation itself. And last comes the circular, because circular is only the understanding of the revenue authorities, what they understand. It is not the understanding of the legislature or the courts. And we should understand one more thing, that any law which is passed by the parliament in India, unlike in Britain, in India, the law itself can be struck down as being violative of the fundamental rights of the citizens or any other person. Some articles are applicable only to citizens, some are applicable to all. So when you look at a legislation and when you go to challenge a legislation or a rule or a notification before the courts, you must understand the court basically is looking at the act first and the rules and notifications next, and only the circular at the last. One such challenge was made to the very Compensation Cess Act and rules in what is reported as Union of India versus Mohit Mineral in 2018 before the Supreme Court. The compensation cess was challenged on the grounds that there is no legislative competence. It was a heavy challenge that was made by the petitioners. And they said that essentially what was the facts of the case? Clean energy cess which was paid prior to 36/2017, they wanted to set it off against compensation cess, which was payable from 1/7/2017. So the challenge was made to the very provisions of the Compensation Act, the cess. And a set-off was also claimed. The Supreme Court upheld this Compensation Cess Act because it was in pursuance of a scheme arranged where the states would be compensated by the center for fall in revenue on account of implementation of the GST. All of you know that the center is now, because of the COVID situation, struggling to pay this compensation cess. The revenues have drastically come down. Of course, now they have picked up again from last month, but there was a serious financial crunch. Coming back to the decision, the constitutional validity of the compensation cess levy was upheld. In doing so, however, the Supreme Court relied on an earlier decision as far as the set-off is concerned. Setting off clean energy cess against compensation cess. In a very short paragraph, the Supreme Court said that set-off of credit is a concession given by the legislature. And if that concession is not there in the legislation, it cannot be done. So in other words, the set-off was not allowed. This is where I feel, with due respects, that the Supreme Court could have looked at the Constitution Amendment Bill which was passed. Why GST was introduced? One of the objectives of introducing GST, there are several objectives. One is harmonization of the trade in the country. Two, tax rates will be uniform across the country, making it easier for people to plan their activities. Three, several indirect tax levies and enactments will be merged into one legislation. And fourth, very important objective, which I would say, is that there must be a seamless flow of credit, and that would allow taxation of value addition at each point of supply. Now, it is this objective which I believe that the Supreme Court has not noticed, or it has not been shown to them, or whatever be the reasons. It appears to me that in the earlier legislations dealing with value-added tax, VAT Act, the Excise Act, the Service Tax, all of this could have been interpreted by the Supreme Court in their earlier decisions in Jaim and Company or TVS Motor as concessions by the legislature. But when it comes to GST, my humble view is that it is a constitutional objective to give seamless flow of credit. So anything that blocks the seamless flow of credit should be struck down. I'll give you several examples which I feel are against the very spirit of the introduction of the GST, as stated in the Constitutional Amendment Bill which was introduced. One is that by the place of supply rules, you limit credit within a particular state, set off within a particular state. Take, for example, the hotel industry. Hotel industry can, if I go to Kerala, stay in a hotel and come back to Bangalore, I can't take the credit because that bill will say CGST plus SGST of the particular state. I can't take that credit in Karnataka. Now, is this not against the very objective of the GST regime? One state to another, I cannot take. Why can't I take the credit of CGST which is paid in one state against another state? I am not able to understand this at all. That credit flow should be seamless. After all, the revenue goes to the central government. There is no reason why the CGST paid in Kerala should not be allowed as credit to me in Karnataka. I can't see any good reason for it. And if you truly want to avoid cascading effect of taxes, it should be a seamless flow of credit. If you want business to flow out from China and come to your country, you should make it easy for people to operate in India. Why is it that we're not seeing such an exodus coming into this country directly, and it is going to countries like Vietnam, Korea? The reason is simply this. One, the infrastructure. Two, the people. Three, tax. Tax administration is very important for us to have. We cannot have officers who have not trained in the legislation administering an act. We cannot have officers with the old mindset administering this act. We cannot have bureaucrats who are used to the excise and customs and service tax regime to follow through into a GST regime and implement something completely different. That is the reason why we are having this difficulty. So this decision of Mohit Mineral, unfortunately, has not dealt with that aspect, which I would have been very happy if that they had dealt with. This is not the last time that this challenge is going to come. We are going to see a challenge to this on the principles laid out in the Constitution, that seamless flow of credit should be allowed. It is no more a concession. What I'm trying to tell the viewers is, it is no more a concession. It is not a concession given by the legislature to the taxpayers. It's a constitutional objective. The objective is to allow credit. You can't put artificial restrictions on this credit mechanism. That is my humble view. Duty-free shops, what is their position in GST? Probably in 2019 itself, the Allahabad High Court, Natin Krishna, very clearly put this. Duty-free shops that are situated at the customs area, they do not come within the customs frontier. That is, the goods don't leave the customs frontier. And therefore, the question of them, paying any GST will not arise. This was a very good decision because they analyzed what is the customs area and what is the warehouse which falls there, and how duty-free shops supplying goods to the people outside India cannot come within the clutches of the IGST Act. Fortunately, the government, seeing the type of confusion that is coming up in the GST regime, inserted entries into Schedule 3 to say that supplies from warehouses will not be considered as a supply at all. It's a welcome amendment that they did. Consequent to the decisions of the Allahabad High Court, the Bombay High Court, in many of these decisions, they brought about a welcome amendment to say that warehouses which store duty-free goods, or where goods are stored before clearance from customs, Up to the point they are stored in these warehouses, there will be no question of them paying any tax. If there is a warehouse to warehouse transfer, there will be no GST or GST. It is only when it is cleared from the warehouse into the territory of India, so as to say, I'm not saying that the warehouses are not in the territory of India, so as to say, when they cleared so that they mix with the rest of the goods in India, that the tax of IGST will become payable. So, Atin Krishna's decision of the Allahabad High Court was, and Sandeep Patil's decision also of the Mumbai High Court, these two decisions are good to read to find out how the courts think about what is the customs area and what is supply. One of the challenges that has been made has been even from the service tax regime is ocean freight. Whether tax is payable on ocean freight at all. Now, what do you mean by ocean freight and tax on ocean freight? Let me explain that to you in some detail. Let us assume that I'm importing certain goods from Japan. The Japanese exporter says that I will supply you these goods on CIF basis. CIF basis means that the cost, insurance, and freight will be built into the price. And it will come to me. One of the difficulties that was being faced by the Indian importer in CIF prices is this. The Japanese exporter will enter into a contract with his shipping agent or a sea shipping line for transport of the goods and insurance of the goods and freight payments. And he'll send the goods to me, I will receive the goods. Virtually, if you see, it is impossible for me to know what is the freight element that the Japanese exporter has paid to his shipping line. That is between two people who are located outside India. The IGST notification 8/2017 and 10/2017 requires the importer to pay tax on that freight element, which he does not bear at all directly. It is only indirectly billed to him. So the question was that this very levy, the notification 8/2017 and 10, were challenged in the Gujarat High Court in Mohit Minerals case. In what I consider it to be a landmark decision, this was in 2020, the decision came out. This was challenged in both the service tax regime and the GST regime. We are talking only of the GST decision. What did the High Court hold? What the High Court held was these notifications which make an importer liable to pay tax on ocean freight, which freight is not at all paid by the importer, but is something paid by the Japanese or the exporter to his shipping line, is ultra virus. Why? Because it is unreasonable, one, to expect the importer to at all pay for something which he is not even a party to the contract. So paying tax on that freight element does not arise. One. Two, the transaction takes place between two people outside the country, the taxing territory of India. The Japanese exporter and the shipping line, both of them are outside the country. It is a transaction, a contract between those two. The Indian importer has nothing to do with it. So taxing the importer for a contract entered into by two different people is completely erroneous. Three, and this is very important, when the goods come into the country, when the Indian importer clears the goods, he will be paying IGST on the goods, the value of the goods. That value of the goods includes the freight element. I have already paid the IGST on the freight element once when I clear the goods. Where is the question of you again saying that I am going to pay the tax because of notification 8/2017 or 10/2017. I feel this notification should now be, this entries should be amended or withdrawn, because you can't have double taxation. Once when the goods are entering into the country, you're anyway paying the GST on the total value, which includes the freight value. Having collected it once, you cannot collect IGST again when the amounts are remitted. So in my view, the decision of the Gujarat High Court is completely correct. And though the trend today, as of not just today, the last 10 or 15 years, the trend has been that every adverse decision of the High Court, people will jump and go to the Supreme Court. And I don't blame the department, because this is a substantial question which has to ultimately be decided by the Supreme Court. But in my view, the decision of the Gujarat High Court is correct in law, and I hope it gets upheld by the Supreme Court in due course of time. But fact of the matter is, today you have a High Court decision which says so. Similar matters are also pending in several other courts, and probably will come up one by one for argument after this COVID situation improves. There is one very interesting decision of the Mumbai High Court, Bhai Mamubai trust case, which this is a case where this is a very interesting case.
Hello, sir.
So, yes.
Sir, just a minute. Sorry to interrupt you. Just a small announcement to all viewers. So please post the questions to all your panelists and not directly to the speaker. The question will be taken up by the moderator. So please post your questions to all the panelists. Thank you, sir. Sorry for interruption.
No problem. So where was I? Bhai Mamubai trust case of the Mumbai High Court is a very interesting decision. This decision actually talks of, the Civil Procedure Code. In the Civil Procedure Code, when there are property disputes between two people, to protect the property, the court sometimes appoints what is called a receiver. A receiver is a person who will collect all whatever is due to the property. Supposing the property is rented out, the receiver will collect the rent, keep it with him, and then when the court decides the title suit, either in favor of the plaintiff or the defendant, as the case may be, all these monies will be paid to the party who is found to be the owner of the property. Now, one of the questions that came up here was whether the fee which is received by the receiver would be taxed under the GST law. Can you say that it is a consideration for supply of services? Let me tell you, I have been hearing some views that service definition includes everything under the sun. Everything is, if it is not goods, it has to be taxed as services. Let me remind the viewers, that is not the law. Goods and services are two sides of the same coin. Please take the decision of all Supreme Court All India Tax Practitioners Federation case reported in 2007 SCC. Also see in 2011 SCC the Leasing Association case. The Supreme Court says there is no difference between goods and services. Basically, what is generally, this is the distinction, not to be used always. Generally, the distinction is something tangible and movable, it is goods. Something which is intangible becomes services. It is not that everything under the sun is service. It is not so. There are several things that have to be kept in mind. One is, it should be services. It should be in the course of business. It should be for a consideration. Only on, if these conditions are met, can it be brought to GST? Some exceptions are there in Section 7. But the general law of GST is that it is a business tax. It is not a tax on your personal income, or it's not a tax on your personal supplies. It's not so. The supply should be in the course of furtherance of business. If it were not so, all the housewives will be taxed because they do maximum services to their husband. Or the husband does maximum services to his wife. If that were the case, they would all be subjected to tax. It is not so. Please read this decision. It is reported in 2019 TIOL, where the High Court makes a beautiful, analysis, and we should praise also the counsels who assisted the High Court in arriving at this conclusion. And one important thing in which I would like the viewers to keep in mind is that when you talk of consideration, automatically it means that the Contract Act will come into being. You may have a definition for consideration in 2(31). But I have found a lot of speakers confusing between conditions and consideration. Conditions to the contract doesn't make it consideration. For example, in a developmental agreement which I enter into with a builder and landlord, may put several conditions. If you take this society redevelopment which takes place in Mumbai, the society will want a new flat to be built in the place of the old flat. They will get extra TDRs which they give to a developer. The condition that he should construct new flats in lieu of the old flats, that clause is a condition, it's not a consideration. It's a condition. You can't tax that. What you can tax in the hands of a developer is only what he gets as consideration, the extra TDR, not the entire, the extra TDR. That is the one which he gets, which he can sell. That is the only thing you can attempt to tax. I'm saying attempt to tax. I'm not saying you tax, because there are several other grounds on which you can say the tax is not paid. Developmental rights being itself a immovable property. Now, coming back to this decision, what the High Court said was, there should be a reciprocal relationship existing between the parties. If there is no reciprocal relationship existing between the parties, there can be no GST. There is no compensation, damages. These are not arising out of reciprocal relationship. He's collecting this, keeping a fees is through the order of the court. It is a protective thing that is being done by the court. And therefore, you cannot tax these receipts. Please keep in mind, this is the difference between arguing before the departmental authorities and this authority for advance rulings, which I call adverse rulings, and high courts, where questions of law you can argue in a more effective fashion. One other decision which strikes me is that the Maxim Tube's decision of the Gujarat High Court in 2019 TIOL. Here the Gujarat High Court, I would say, went into several aspects of Article 14 and 19 to say that the conditions relating to pre-import in an advance license, conditions of physical exports in an advance license, the amendments made have to be struck down as being unreasonable. It's a landmark decision, and those who really want to know arguments on Article 14 and 19 should read that judgment, because after that, of course, in 2019, the government realized its error and amended the notifications and did away with this pre-import and physical exports conditions. But nevertheless, it is a good landmark decision to show that High Court can strike down conditions in the notifications which are unreasonable or are arbitrary and contrary in the provisions of Article 14 and 19 of the Constitution. It's a good decision to read. Constitutional validity of setting up the appellate tribunal, that is the GST tribunal. The Madras High Court and Revenue Bar Association struck down the composition of the GST, and this was, in fact, the senior counsel who argued it beautifully, Mr. Datar. In our discussions also, I had once mentioned to him that you can't have a tribunal with 2 technical members and 1 judicial member. It is nothing but authority for advance ruling. That was one of the bases where the Madras High Court, there are other arguments also were taken. One of the bases for which the GST, setting up of the GST was struck down by the Madras High Court. And the matters are now pending the Supreme Court. That is the reason why the GST have not been set up anywhere in the country. In fact, the setting up of the GST is an absolute essential for the GST law to progress, for speedy justice to be done. The Supreme Court, of course, we can't blame the Supreme Court. There are so many matters which are emergent today. Every matter becomes emergent, but for tax administration, for people who are involved in tax administration, we need an appellate tribunal to be set up as quickly as possible. And there should be a majority of judicial members. There should not be a minority of judicial members. That is what I feel should be done immediately. Now, even the validity of constitution of the AAR has been challenged in Rajasthan High Court, and notices have been issued. No, there is no final decision or interim decisions. Why they have challenged it is because authority for advance ruling does not have any judicial member at all. When you say that it's an authority for advance ruling, and that authority is going to decide in advance so that your disputes come down, is it not necessary that it should be invested with a judicial member? Now, if you look at the history of authority for advance ruling the last 3 years in GST law, you will all agree with me that 99% of the decisions go against the assessee. Only 1% may, that too where notifications are present in favor of the assessee. The authority for advance ruling says, yes, this notification present, this circular is present. Basically, the fundamental issue with our AARs is that it is packed with only the departmental officers of the grade of maybe additional commissioners or chief commissioners or joint commissioners. The fact of the matter is that only these people are sitting. Now you have formed the appellate authority for advance ruling. That is also packed with these fellows only. Next, you have planned a national appellate authority for advance ruling, and that will also be packed with all these retired people. Now, what is the use of having only these departmental fellows sitting and deciding on important questions of law? Important questions. Why can't you have the retired judges to be sitting as one of the members? At least some decorum, some element of fairness will come into the system. If you are serious about the AR's functioning, my suggestion would be that it should have a judicial member for it to succeed. Otherwise, I would tell all my professional brethren, as I have always been telling, please avoid this institution for any purpose. Now let us look at a very important decision which has been reported a few weeks back. Material Recycling Association of India. This we will discuss at some length. The validity, constitutional validity of section 13(8) subclause B of the IGST Act came to be challenged. What is this section? It is essentially this. Now I am an agent in India. I do some business promotion services for principals who are located outside India. That means I market their products in India, I get a commission. Now this commission comes to me in foreign exchange. But because of the place of supply provisions, I am subjected to tax in India. Though I am earning foreign exchange, I get taxed. Because one of the conditions in services, the definition of services under the GST Act, one of the conditions is that the place of supply should be outside India. In cases of agents who get foreign income, all agents, their place of supply is deemed to be in India because of Section 13(8). For this reason, they get taxed under the GST. So this was challenged. Unfortunately for us, the Gujarat High Court held that this challenge is invalid and that this has been the position from service tax days from 2014. This has been the position. Therefore, there is nothing new in it. The constitutional validity was upheld. Unfortunately, in this decision, certain issues were probably not argued or considered. When you look at what an agent does, when you challenge the constitutional provisions, this is what I said at the beginning. You must rely on the act and rules and compare it with legislations outside the country. Circulars are going to be of no use when you go to courts. If you look at what should have been argued in this case, how is an agent different from any other exporter? The Gujarat High Court said there is a difference. One person, the place of supply is in India, one is outside India. So therefore, the parliament is competent to make an agent taxable and another person not taxable. What should have been argued in Material Recycling Association is this: the consumption of the services takes place outside India. This was missed, completely missed. Sorry to say. See, when arguing matters before courts, we should give up our ego. We should make sure that not just one council, maybe 2-3 councils are also there who can argue these cases. It is not possible for one council to have so much knowledge that he can argue on everything. Even if it is so, it's always to have more than one brain. Nothing wrong in it, in having more than one brain being put into a matter and argued. In this case, the consumption, see, essentially GST is a consumption tax. If it is a consumption tax, the consumption should take place inside India. Concept of GST worldwide is that it is a consumption tax. It is not a producer's tax. It's not an income tax. It is a consumption tax. It's a tax on consumption. The incidence always falls on the end consumer. All the people in between, the manufacturer, the wholesaler, the retailer, they only collect a tax and pay it to the government. It is revenue neutral for them. Ultimate tax is borne by the consumer. So in this case, if you look at it, who is the agent employed by? He is employed by the foreign principal. His services are consumed outside India. So 13(8)(b) militates against this concept of consumption tax. By putting the place of supply in India and taxing him when the consumption of that service takes place outside India, you have gone beyond the very concept of GST in putting this restriction. You may be competent to say what is a place of supply, But are you competent to tax something on which the consumption is outside of the country? This is the question that should have been asked before the Ahmedabad, the High Court, and was not asked. Why exports are not taxed? Exports are not taxed on this principle. One, that you are exporting goods, you are exporting services, you do not export taxes. This is the salutary principle. When the consumption of goods and services goes outside the country, tax should not follow. You can't tax the transaction because the consumption goes outside the country. Outside your territorial limits, the consumption goes. This is a classic case where the brokers or the intermediaries, the consumption of their services takes place outside India. They are answerable to the foreign principal who pays the commission. They are not answerable to the Indian person to whom they, market the goods. They don't get a commission from the Indian party. They get commission only from the outside party. The concept of consumption tax worldwide. What do you mean by consumption tax? The concept that in India, consumption tax has a territorial nexus to the territory of India. And that if the consumption goes beyond the borders of India, the transaction cannot be subjected to tax in India is an argument that should have been taken in Material Recycling Association of India's case. It is not just enough to say that it is constitutionally invalid. No. Why is it constitutionally invalid? Constitution says the GST law will apply in certain cases. Now, please look at it. I know that there could be some very eminent advocates and chartered accountants who are here, who are listening to this. Please look at 269A of the Constitution. When there is a supply in the course of interstate trade, goods or services. What do you mean by course of interstate trade or services? What do you mean by this course of interstate? Constitution says in 269A, import is also in the course. That is, in the course of import, transactions in the course of import are also interstate. Perfect. I will read out the provisions of 269A and people will understand this better because it is a seminal point. Taxes on the sale or purchase of goods and taxes on the consignment of goods. Goods and services tax on supplies in the course of interstate trade or commerce shall be levied and collected by the government of India. I stop there. Others are not necessary. For the purposes of this clause, supply of goods or services or both in the course of import into the territory of India shall be deemed to be supply of goods or services or both in the course of interstate trade or commerce. So they say the powers to tax interstate trade or commerce, the course of interstate trade or commerce, the powers to tax will be of this union. And for that purpose, transactions in the course of interstate, in the course of import will also be considered as in the course of interstate. Nowhere in the Constitution it has been said that transactions in the course of export will be considered as interstate. So when we're discussing this Material Recycling Association, I put forth this submission to all my brethren and all my sisters who are present here, that the entire provisions relating to which are there in IGST Act, the CGST Act, the rules 88, 89, 90 are all ultra-virus, are all unconstitutional because The Constitution does not recognize any legislation on goods and services tax putting any condition on exports. Exports is not interstate, exports is not intrastate. And on this ground, emphasis on 269A should have been laid forth in this Material Recycling Association of India's case. Had these 2 points been laid forth, I'm very sure that this the Ahmedabad High Court in Gujarat would have come to a different conclusion, because I'm consistently seeing that High Court taking views that are in consonance with the taxation principles. When you go to High Court, you should talk of principles. Should not tell them RFD 1 is not okay, RFD 2 is not okay. That is not what High Court expects you. They expect you to talk the principles of taxation. These 2 principles, in my humble view, could have been brought out before the Gujarat High Court. Nothing is lost. There are other High Courts which are present. We can bring it forth before them. Nothing will be lost. One of the agitated issues in this GST is, can still demand notices be issued of service tax, excise, all these sales tax, all these legislations? Can they still issue demand notices demanding those taxes? This matters went to the Kerala High Court, several other high courts, and those high courts upheld the validity of section 174, especially the Guwahati High Court and the Kerala High Court upheld the validity and said, yes, you can. But there is an interesting decision in Reliance Industries case passed by this Gujarat High Court. It's a classic decision. Classic because the discussion that the way the counsels have argued it, the way the judges analyzed it, it's a treat to all of us to read it in full and learn a lot. See, we argue cases in High Court. It does not therefore mean that others are not arguing. There are so many learned counsels, senior to us in this profession, who argue so well, from whom you can learn a lot. We should not think that because we have been dealing in indirect taxes for 30 years, we are the soul and whole in the entire country. There are hundreds, thousands, lakhs of people who are better than us. This is one case where I learned a lot of principles, and I'm thankful to the counsels who argued this case. What is this case? In this case, in Reliance Industries, I will not go through the facts because the facts are very detailed. I'll just tell you what the gist of the issue was. Gist of the issue was, in 2018, the legislature in Gujarat amended the VAT Act. VAT Act had already expired. To amend the VAT Act, they passed legislation, now an amending act, so that revision notices that were sent will become valid. Gujarat High Court beautifully analyzed this and brought out some very salutary principles. What they said is this: when you amend an act today, the legislature today should have the powers to amend the act. If you look at the Constitution Amendment Act, which was introduced, said the Constitution Amendment Act came into effect from 16/9/2016, that is September of 2016, and said all the existing laws will be valid for a period of 1 year, that is 15/9/2017, or when the GST Act is introduced, whichever is earlier. Because GST Act was introduced on 1/7/2017, all those acts were repealed. Notwithstanding the repeal, they continue to be in force up to 2017. Fine. Very good. Now, the question arose that can I make an amendment in 2018 of an act which has already expired? That was the question. And the Gujarat High Court said, no, you can't do it. Why? Because today, if you see, one of the salutary principles in constitutional law on powers of the legislature, as laid down by the Supreme Court in several decisions, is this. The legislature which amends should have the power. That is, the legislature will pass the act, we are not bothered about. We are bothered about in 2018 which legislature amended this act. And if you look closely at 246A, which has overriding provisions, it says both the legislature, both the center and the states are competent to enact a GST. So Gujarat High Court held that only the state government exercising this power is unconstitutional. It cannot be done. So you can't amend an act after it has lapsed completely by somebody who's not given the exclusive power. Earlier to 2017, you had exclusive power, no doubt. No issues with it. But after 2017, you did not have exclusive power under 246A. 246A. You have only shared power with center. This is how the Gujarat High Court. It is an interpretation that could be subjected to arguments, subjected to pros and cons. Fact of the matter is a very new thinking which was introduced by the Gujarat High Court. They also said that under Article 14 and 19, it is unreasonable to make these changes to get over a court decision, but that's a different issue. That's a different issue. This decision is a landmark. Now let us look at one other recent decision that shocked me. Fortunately, it will not apply to our GST law, but nevertheless, it is interesting to note. International Hospitals case, the Allahabad High Court had taken a view that if you put a stent in a man's heart, it is not sale of goods. It is medical services and therefore cannot be taxed under the Sale of Goods Act. Because the person who goes with his heart damaged does not know what a stent is, he may know. He's not interested in buying and selling stent. His interest is to come out alive first. And come out to the extent damages can be prevented. That is his objective. He's looking for medical services. In the course of providing these medical services, a stent may be introduced into your heart. Stent be put into your heart. Likewise, several people will require several implants. Today, if you see cosmetic surgery which is happening, implants are put in. Pacemakers are put into the heart. Dental surgery requires a lot of implants to be put. Your jaw may have to be changed. Many people change their nose. Many people change their several parts of their faces to look better than what they were born. Now, in Mayat hospitals, the Madras High Court considered this question. Whether all these implants that are put in, stents which are put in, pacemakers which are put in, can you classify them as works contract? And in spite of some brilliant arguments made in Mayat Hospital's case, I can tell you this. The counsels who argued this case have argued this case very well. In spite of their argument, strangely, the Madras High Court took a view that I'll read it. There is not only transfer of possession of prosthetics into the physiology of the patient, but also the ownership of such prosthetics for the patient for consideration in the course of provision of medical health service. Therefore, it's a works contract. I do not know, sir, how it could be considered as a works contract. Works contract work is the principle is completely different. Madras Court discusses that also. Says the principle initially was an immovable property. Now it has come to so many fields. We should understand that what is one of the important things which I believe that the High Court should have considered, and these arguments were taken. What is the consensus ad idem for this? In contract, consensus ad idem means what do the two parties have in mind should be identical. The buyer and the seller should have an identical view. Have you ever heard of any patient coming out of the hospital and telling, I own this stent in my heart? Nobody will say it. I own this prosthetics in this face. My nose has been filled with the implants and therefore I own my nose. Nobody says this. It's rather funny that we miss the woods for the trees. Fortunately, this decision classifying it as works contract is not applicable to GST law because under 2-119 of the Act, CGST Act, works contract means several activities in relation to immovable property. And I am very happy that human beings are not immovable property and this decision will not apply in the GST law. But this decision, the earlier it is set aside, the better for us. Now, transitional issues, I can tell you this. Several high courts have held transition credit. Please don't look at it as an input tax credit under Section 16. Section 140 is different from Section 16. 140 is only all the credits which you earned earlier, which nobody questioned. You're carrying it forward. That's all. Why do you have to compare that? I'm very disappointed that we have so many cases on transitional credit. So many high courts have told the department, please revise these TRAN ones manually, if not electronically. And I'm very sorry to say that the government, even before the courts, is taking an extremely negative view, and somebody should bring it to the knowledge of the higher ups in the government, not in the bureaucrats, but outside the bureaucracy, that this is destroying the image of ease of doing business. Several high courts have told you, please open it manually. And instead of doing so, the government, the CBIC, has issued a detailed instruction how to defend such cases. Very unfortunate. Very, very unfortunate. When you say that your objective is to make seamless credit happen, you are putting an embargo on the credit which was done in the earlier period. You have collected the GST on the end product already. You don't want to give the credit which is carried forward. This is a very, very unfortunate. You have several decisions of Karnataka High Court, several decisions of Delhi High Court, several decisions of all other high courts which have said that it is unreasonable to deny this credit, whatever be the grounds. Unreasonable to not allow them to revise. Mistakes are made by not only department, even by the assessees. Nobody is saying no. We have also made errors. What is wrong in you allowing you to do the revision? You have submitted a TRAN 1 form. Can you not revise it? Why are you blocking people from revising it? I can't understand this. There are so many decisions. Brand equity case of the Delhi High Court, which of course has been taken to the Supreme Court. Siddharth Enterprises, which has also been taken of Gujarat High Court, taken to the Supreme Court and stayed there. Adford Technologies, Punjab and Haryana High Court, which has been affirmed by the Supreme Court since the SLP was dismissed. SKH Sheet Metals case of the Delhi High Court, which deals with the decisions of the earlier Delhi High Court beautifully. Even though they made a retrospective amendment, one of the grounds which are taken before the Delhi High Court was that Section 140 does not prescribe a time limit. You could not have done it in the rules. That was upheld. So to get over that decision, a retrospective amendment was made. But they have not made any further amendment to look at the other aspects of this Delhi High Court decision. What does the Delhi High Court decision say? Unfortunately, the government has lost sight of it. They said, when you say that there are technical glitches, what do you mean by technical glitches? It's not defined. Rule 117(1)(a) does not say what do you mean by technical error. Is it on the side of the department only that you are going to do? And if the human error happens because of technology on the assessee's front, you're not going to allow it? That is a very, very unreasonable classification. Beautiful decision of the Delhi High Court. This has not been rectified by the government. And in my view, the government should gracefully accept all the transitional credits and allow this credit. They should not block this credit. This is my humble view on this. What about the old credits? You had so many education cesses and higher education cesses and Krishi Kalyan cesses where you would have had the balance. Now you brought it forward. Government said you can't take that credit into your electronic credit ledger. Madras High Court passed a decision, Sutherland Global Services, saying you can take that credit. Government has now tried to rectify that by passing some amendments. Now we have to see whether the Madras High Court decision will still hold good or not. Let us see how it holds good or it does not hold good. We'll have to, in my view, it's a very good decision which has come about. Then comes, of course, the decision in AAP's case, where the Gujarat High Court has said that Form 3B, GST 3B is not at all a return. It is only a memorandum. Fortunate I was to argue this matter in the Karnataka High Court at length on an issue where the assessee's credit was blocked unilaterally by the department under the so-called Rule 86A without any reason, and invocation of Rule 36(4), restricting the credits to 10% and 20%. Both these matters I was fortunate to argue at length in the Karnataka High Court. And the High Court was pleased to admit these appeals for final hearing. As also, they ordered the lifting of the blocked credit so that the assessee could use the credit. This argument of mine was on several grounds. One ground was that the Gujarat High Court has held that GST 3B is not a return at all. Even though there is a retrospective amendment, I was able to show to the High Court that this retrospective amendment does not get over the Gujarat High Court decision where it is said that it's only a temporary measure. GST Council's minutes talk of GST 3B as a temporary measure. But when they wanted to get over this decision, the council minutes simply say Gujarat High Court has held against, and therefore we will amend the law with retrospective to make GST 3B as return. So in my view, the AAP decision will still hold good irrespective of this amendment made. Of course, it has to be tested before the Supreme Court. where the appeals have gone, and we'll have to see how good it is. Next, I come to another very important, very recent decision. Beautiful decision in VKC Footsteps case. I told you some time back there was a Gujarat High Court decision in this material recycling where the agents were brought to tax. And VKC Footsteps, where several lead seniors argued this case. This is the advantage of having more than one brain arguing. Several aspects of GST law was discussed in this case. What is this case? This is a case where the inverted duty structure led to accumulation of credit. VKC Footsteps is manufacturing footwear, which attracts 5%. Most of their inputs and input services are taxed at 12% and 18%. So credit was accumulating. Section 54 bracket 3 specifically says that you will get a refund of unutilized input tax credit. Input tax credit is defined in section 262 and 263 if you read both together. It does not make any distinction between input services and capital goods. It simply sets out the taxes which have to be considered for input tax. That's all. Proviso to section 54 bracket 3 says, if you have an accumulation because the rate of inputs is more than the rate of the output tax payable, then you will be entitled to this refund. Rule 89, which they amended, in fact, in 2018, initially allowed the refund. They amended it to restrict the refund only to the inputs. It was a retrospective amendment, which they said only to the extent of input accumulation I will give you, input services and capital goods I will not give. Please understand, the High Court in Ahmedabad deals only with the input and input services, does not deal with capital goods here. What the High Court said is this. The section allows refund of unutilized input tax credit. Input tax credit is defined as all the tax credits that are available. It does not talk of input or input services. Proviso to section 54(3) puts a condition that the rate of inputs should be higher than the rate of output. That's all. Once you find that the rate of output is less than the rate of input, the entire credit should be refunded to you. And therefore, the rule 89(5), which restricts that only to inputs, is invalid, is beyond section 54. This is a welcome decision of the Gujarat High Court. I'm sure not only will this decision be taken to the Supreme Court, our government may even think of amending the law because they don't want to part with this refund. The problem is, I will tell you, when it is originally framed, some broad-minded person would have thought of it. He would have seen several international practices and brought in this legislation. But when day-to-day working, when it happens, it is interested to some bureaucrat who does not have that vision. Government revenues are very comfortable, doing very well, no amendment. Government revenue is not doing very well, immediately attack this input tax credit chapter completely. Make it unworkable. Put in several restrictions. Restrict your refund. Don't give refund. It is this aspect which the government has used regularly to kill business in India. And therefore, this kind of changing, this kind of amendment, day-to-day amendment, which happens in the GST. What is the international perception of GST in India? Welcome move. But everyday changes is a nuisance. We don't know what's going on in this. I can tell you with confidence that I don't know what is going on in GST law many times. Because every day you have some, amendment or the other happening. And that is not for the good. That is not for the good at all. You cannot have so many amendments happening in the GST law. VKC footsteps is good for so many reasons. One, several advocates, seniors argued this case. Two, the principles behind value-added tax was beautifully brought out. What are the principles? How do you interpret a proviso vis-a-vis the main provision? How do you interpret rules vis-a-vis the act? All these aspects were brought about very well by several councils, because of which the Gujarat High Court said, yes, you should be entitled not only for input tax refund, but also input services refund. It's what you say, a welcome decision, and I simply hope the government does not go back on it. Now let us look at another decision which this was in 2019, fairly old decision as per today's standards, but is a landmark decision of the Orissa High Court. I will explain it this way. It is called Safari Retreats Private Limited versus Chief Commissioner. Section 17(5) talks of blocked credits. Now, if I am a builder, I can take credit because the property is held as my stock in trade. Let us assume, as a builder, I capitalize the flats or the commercial offices which I'm building because I don't want to sell them. I want to rent it out. 17(5) says these are blocked credits. The moment you capitalize this, you lose the credit. You can't take your works contract credit. You can't take credit on your input goods or services. What it says, the law says that if you sell the goods before completion, you pay GST. Therefore, I will allow you to take credit. If you sell this after completion, you don't pay GST. So to that extent, I'm not going to allow you credit. The moment you capitalize it, no credit at all. But this builder who capitalizes it will rent out this commercial premises and he will pay GST on the rent. This was denied by the department. What did they say? No, you can't, because you capitalized it. Orissa High Court held, and rightly so in my view, that where the tax chain is not broken, you should not restrict the input tax credit. Tax chain is broken, you want to restrict, okay, fine. This is not a case where the tax chain is broken, where the person sells off his property, no. He constructs a mall and that mall generates rental income. On that rental income, you pay GST. So the tax chain continues. If the tax chain continues and ultimate rental, he pays this tax, you should allow him the credit in the first instance. Beautiful analysis. Not allowing him credit will fall foul of Article 14. You allow another man's credit because he's selling before completion. Why don't you allow this man who holds on to the asset and actually pays tax on the lease rental income? To my mind, this is a beautiful decision. Of course, it is also now before the Supreme Court. No stay has been granted to the best of my knowledge. It's before the Supreme Court, but in my view, it's a very good decision and should be followed by all. Now, you may ask me, Now we come to an interesting discussion. You may ask me, what happens if Supreme Court reverses this? What happens to my client? What will happen? Whatever tax credit was taken will be repaid. Fine. What about the interest? In my view, my humble view, I have filed petitions in the High Court, and they have also been notices have been issued and stay granted by the Karnataka High Court on this point, that interest, there is no substantive provision for the charge of interest in section 50. Section 50 says that interest to be will be charged in the manner as may be prescribed. See section 50 bracket 2. The term as may be prescribed is defined in section 2 bracket 87 to say as prescribed by rules. I was able to demonstrate to the Karnataka High Court that there is no rule which prescribes the interest calculation. There are some rules in, say, Rule 37, Rule 42, 43. Those don't apply to these kind of situations. Such a rule is not prescribed. So the section 50 of the Act is unenforceable as of today in respect of such cases. Come to section 50 bracket 3. It talks of interest chargeable only when there is a mismatch in the input tax credit. It does not talk of interest chargeable when you take credit on a particular interpretation and that interpretation subsequently is held to be wrong. It does not talk of interest in those cases. It only talks of mismatch of. Therefore, in my humble view, interest is not payable in these cases. Third, penalty can never be levied because when the time I took credit, I had an Orissa High Court judgment in my favor. So there's no question of me being penalized. Court decisions today are in my favor. Therefore, the message I would like to tell to chartered accountants is advise your clients to take this credit. Advise them to take the credit. In my view, interest and penalty is not payable. Maximum what will happen? Assume Supreme Court says that this is not, credit is to be denied. It's only the credit amount which will be denied. If you want to be very safe, keep that credit with you. Don't utilize it. My view, even if you utilize it, there is no question of payment of interest or penalty. That is my humble view. Can be tested in a court of law. Fortunately, in this interest cases, I was able to convince the court in Karnataka at least that I should get a stay on this provisions. Several assessees, all small-time assessees from Mysore and other places who are seriously affected. I'm saying individuals for whom some other lawyer had, placed the petitions and wanted me to argue it. These are all individual assessees, and I think the lordships were very kind in considering these arguments and staying those notices which were issued. In my view, section 50 has to be operationalized better than what it is today. As of today, in my view, it is not fully operationalized. Let me come to certain other decisions which will be of some interest to the people who are attending this session as far as recoveries are concerned. One of the things that is facing the country as a whole is, can I recover the tax under section 79 through garnishing proceedings without doing an adjudication? This is a hot topic which is going on across the Karnataka High Court in LC infra projects. This decision was affirmed by the division bench, specifically said If you want to recover anything, you can't recover it without doing an assessment. You can't attach the bank accounts. You cannot issue notices to the clients of the assessee, garnishee orders, unless you do an assessment. And that assessment, especially even if it is interest under 50, you will necessarily have to do an adjudication. Follow the principles of natural justice. You have to follow the principles of natural justice before you do this. And therefore, the decision of the Karnataka High Court in LC infra projects was very clear. This was followed by a decision of the Jharkhand High Court in Mahadio Construction Company's case, where also they said the same thing. 79, you can't go immediately till such time you do an adjudication. The Madras High Court, where there's a difference of opinion between two judges, even to the third judge, Dejang Moparts Private Limited, they said also the same thing. If you want to do any recovery action, necessarily, you will have to do an adjudication. First find out how much interest is paid. First find it out. Then you recover it. Issue notice to him, adjudicate it. Don't, without issuing any notice, go directly to the bank account, attach it. Now, let me tell you, this is happening in the rest of the country also. We are faced with several proceedings where the department simply writes to the bank and attaches. But once they write to the bank, bankers will not do anything. They have to forcibly hold back. You don't have a choice but to approach the high courts of the country, unfortunately. But now the judicial thinking is that you must and should have an adjudication before you do an attachment. The only provision of law which stands in your way is if you have filed a return, already returns are filed. The department says, is relying on section 75 bracket 12 to say, I can recover the amount once your return is filed without doing an adjudication. Let me tell you why this is very bad in law. I give you two situations. What the department says is obnoxious. What the provision of 75 bracket 12 is obnoxious. Why? Supposing I file a return, I show some tax payable, I have not paid the tax. 75 bracket 12 says you can resort to recovery provisions under 70 directly. Fine. Now let us look at a contrast situation. Another situation where I don't file returns at all. I am a dishonest man, I don't file returns. Therefore, I have not paid the taxes. What will you do? You can't rely on 7512 because I have not filed a return. So you will have to issue assessment notice to me, hear me, pass an assessment order. Then I will go in appeal. I will pay only 10% in the first appeal and 20% thereafter, making it total 30 in the second appeal. So a person who does not file the return at all and is thoroughly dishonest, you are telling him, I will put you through a process of adjudication. I will not recover from you. But a person who files the return but is not able to pay the money, you are telling him, I will recover it from you without doing any adjudication. In my view, it is highly discriminatory, arbitrary, and this provision of 7512 runs contrary to section 39 bracket 7 and needs to be challenged in the High Courts. I have done it in Bombay High Court, I have done it in Karnataka High Court. This provision has to go. You cannot make a law which favors dishonest people over honest people. Partially honest. The fellow who files the return is not able to pay for some whatever reasons. In my view, this 7512 has to be challenged in several other parts of the country also. One decision which is, of course, of some importance to us will be what happens if I file the appeals late? Beyond the condonable period, I file an appeal. Supreme Court examined this in the context of the sales tax legislations earlier in GlaxoSmithKline and said, if you are filing an appeal late, even beyond the statutory period, condonation also you are filed beyond that, we will not be able to help you. But if you're challenged it by a writ petition in High Court, during the period of the appeal, that is, in other words, let us assume my appeal period is 2 months and I am given another period of 1 month of condonation, that is 3 months in totality. Order comes, I file a writ petition within that 3-month period. What the Supreme Court says, in those cases, the High Courts can examine. But supposing I approach the High Court itself after the condonation period, that is after 3 months, I have not filed an appeal also, I have approached the High Court late also. In these cases, the High Courts should not give relief to the assessors. In my view, this decision is very harsh. In fact, the decision in the Electronic Corporations case by the Andhra Pradesh High Court full bench, in my view, they considered it, the Supreme Court did consider it here. In my view, that Andhra Pradesh High Court is correct. They said, if you approach the High Court in writ jurisdiction, we will examine the original order. If the original order is in breach of the principles of natural justice, is an ex facie illegal order, in terms of the powers vested in 226, we can set it aside. That decision in ECIL's case, I think, is correct. And maybe the decision in GlaxoSmithKline, as I have read it, I may have not read it perfectly, there could be a different interpretation to it. As I have read it, I think needs modification to that extent. Detention cases are on the fortunately they have come down during the COVID period because transportation is not taking place to that extent, or though it is taking place to this extent because of making the lockdown or lifting the lockdown, the officers are frightened to go and intercept vehicles. I'm very happy this COVID has done wonderful things. COVID has restored family life to most of the professionals like us, who are going from one court to another court across the country, flying here, flying there, not knowing there are some days which I have got up from the hotel, not knowing where I am. COVID has restored family life. COVID has saved several assessees from attachment orders. COVID has saved so many people from detention of vehicles. And the death rate in COVID is not even 2%. Not even 2%. Recovery rate is 73%. So sometimes I wonder, do we require this vaccine? It has done a lot of good to us. Poor fellow, why should you destroy it? Now, if you look at one decision of the Gujarat High Court in Synergy Ferticum's case, it is a little disturbing to me. They said detention section 129, you can detain the vehicle and recover the taxes. You need not follow the adjudication procedure. You can follow the 129 procedure independently. I think this decision requires to be reconsidered, because look at it this way. I dispatch goods from Karnataka to Gujarat. On the way, it is intercepted in Maharashtra. I have already paid the taxes in Karnataka. Now, when it is intercepted in Maharashtra, that officer there will tell me you pay the taxes with interest, penalty. I would have paid 2 taxes on the same goods. How do I get a refund? Do I have to prefer a refund claim and get it out? What about the interest and penalty? Gujarat High Court has held, no doubt, that for minor errors in this e-way bill, you should not do this. But they should have read down 129 to only talk of contravention during transit. Please understand, this 129, in my view, should apply only when the contraventions take place in transit, not outside of the transit. In transit, I don't have an e-way bill. I don't have an invoice. Such a person should be, you should recover the tax, interest and penalty from, no doubt about it. There I completely agree with the government. But in transit, I have the e-way bill. I have the invoice. Slight mismatches are there. Or I have classified the goods under some chapter. Officer intercepting there says, no, you should have classified it in some other chapter. That is not a valid ground. That is not a contravention during transit. So I'm waiting for a matter where we should file a petition asking for 129 to be read down to only contraventions that appear that happen during transit. I don't have an e-way bill. I don't have an invoice. Yes, I should be penalized. But the penalty should be proportionate to the offense. It should not be disproportionate. There should be a safeguard built into 129. If the tax is already paid by the person who supplied, for which evidence can be produced, you should not recover the tax again. This is my humble view. Genuine cases you should not hold. Cases where you feel, yes, there is some problem, yes, please hold them. Coming to this arrest and luckily because of COVID, again you have to thank COVID. Arrests are not happening now because nobody is willing to come out of their houses. I'm very happy. Small virus which cannot be seen has made us all go and hide under our houses. Before that, the law relating to arrest, I think the decision in Ramana Reddy's case by the High Court, SLP against it was dismissed. In my view, the decision in Ramana Reddy's case may not be correct to say that without an adjudication you can arrest. How will you know that he has offended the law unless you adjudicate? Mere suspicion, can you say, has offended the law? That is where I think the Jayachandran Aloy's case of the Madras High Court was better analyzed by the judge. Where the judge very beautifully brought out in 132, first of all, you should be convicted of an offense. It means that you've committed an offense. It means that if you commit an offense means you should have been proven to have committed the offense, which would mean an assessment should have been done on you. Without doing an assessment, how can you arrest a person? 1. 2. If you look at the kind of offenses that are there in GST, the maximum imprisonment is only 5 years. Maximum. If that be the case, there is sufficient safeguards in the Code of Criminal Procedure which says, if the person is cooperating with you, there is no question of you arresting. Several provisions of the Code of Criminal Procedure is there to say. And decision of the Supreme Court in Arnesh Kumar's case is there which says, if the assessees are cooperating, if the assessees are coming to the police station and answering, In this case, it will be the department. Arrest should be the last resort. You should not arrest a person just because you have the power to do so. And those are cases where the detention, the offenses can be, for which you can be jailed of 7 years and upwards. Even there itself, these safeguards were put in. What about offenses of 5 years? There, in my view, arrest provisions should not be used indiscriminately. You must have provisions for quick assessment, and then if you feel that it is such a heinous crime that they should be arrested, yes. Otherwise, in revenue matters, you must not look at arrest as the first option. It should not be. It should be assessment, recovery, offense, arrest. It should not be the other way around. Arrest him and make sure he pays taxes. That is not how any democratic or advanced country should run. And the provisions of Section 69 as they stand today, even in Ramana Reddy's case, the judge analyzed it beautifully and said it is very inconsistent, very badly drafted. Section 69 is very badly drafted and should be definitely amended. That is where the decision of the Punjab and Haryana High Court in Akhil Krishna Magoo's case is very relevant for practicing chartered accountants. They say those who file returns, whether CAs or advocates, assist the business. They are not beneficiaries. Those people should not be arrested. Good case by the Punjab and Haryana. Only those who partake in the fraud, who are beneficiaries of the fraud, those people you think about arresting. Not those who are preparing returns and submitting it, assisting the business in all transactions. Those are not people who should be arrested. So the Punjab and Haryana High Court has drawn that line beautifully in this case and said so. I believe that is the case that should be followed. And since I have come almost to the end of the session, I have only 5 or 10 minutes. I'll just point out one case where Validity Industries, the Gujarat High Court, this is reported in 2019 DIOL. Gujarat High Court in Validity Industries said even provisional attachment of bank accounts should be done with care. Just because you have authority, you should not provisionally attach. You must ensure that the conditions that are prescribed there are satisfied. And for an assessee who has been in the field for several years paying crores of tax, you should not resort to these methods of attaching the bank account either provisionally or finally, as is the case may. So with this, I think I have dealt with several decisions which I thought were important. I would be now handing the mic back to the organizers who may ask me whatever questions that have been put to me during the course of the session.
So this is Mukul Shingeri, member of the IDT committee.
Yes, sir.
I will be moderating the questions for you for today. Yeah. So the first question that we have received is, does the concept of mutuality apply in GST, especially from the point of view of social and charitable trusts? This has been raised by N. Vaidyanathan.
Mr. Vaidyanathan, you have raised beautiful questions. I had an opportunity, I was fortunate to have an opportunity to argue the Calcutta Club's case before the Supreme Court. So I can tell you that the principle of mutuality will apply to GST law, even though business is defined to include services rendered by or benefits rendered by a club those have to be read as only those clubs which are commercial in nature. Members club, where the members and the club which is following it are one and the same entity, what is called as members club. It's only meant as an agency in principle. These clubs will be outside the purview of GST in my humble view. 1. 2. Charitable trusts. We are not, one is mutuality is completely different. We look at charitable trusts, whether they are at all doing anything in the course of business. In my view, the principles laid out by the Supreme Court in Sai Publication Funds case 114 STC will apply to say that if the main objects of the trust are charitable, incidentally they selling something will not bring it to tax. So charitable trusts, in my humble view, are outside GST.
Thank you for that answer, sir. The next question is by Mr. Sai Prasad. He asks, what are the principles to read down a provision? Question is with respect to read down of section 17, subsection 5, clause C and D in the case of safari retreats.
Yeah. See, you have the courts. It's a very good question. Of course, Sai Prasad himself will know it. He himself is a knowledgeable advocate. He shouldn't be asking me this question. Nevertheless, courts can always strike down a provision if they are ultra vires the Constitution. Articles 14, 19 or any other article 265, 300A, so many. They adopt this method of reading down the statute when they feel that it need not be struck down from the statute. In other words, the reading down principle is adopted to ensure that the provision can exist in law and to make sure that it can apply only to those circumstances which are envisaged by the lawmakers. If you see this reading down principle, was in Bombay Tires case in excise, it was applied, where they read down the definition of relative and distributor. The definition on valuation section said relative and distributor. They said relative, who should be a distributor, or a distributor, who should be a relative, both. Otherwise, it will be too wide. So, if the provisions are very wide and they go against the very concept of the tax law, they can be read down to conform to the constitutional mandate. So this is the principle that is adopted by the courts to ensure that the provision is, if you say it is unconstitutional, strike it off. That means it goes out of the statute completely. But when you read down, it is part of the statute, but the efficacy of the law comes down to answer the objectives of the tax law. This is the principle of reading.
Thank you, sir. Next question is by Mr. N. Vaidyanathan. He asks, based on the case of VKC Footsteps, is it safe to claim the input tax credits on services also in the case of past refunds of such inputs?
The past refunds also, if see the refund provision section 54 gives you a 2-year time limit. So you can go within the time limit and file the refund claims and claim it. Now, if it is beyond the 2-year period, you should give it a try and file petitions in the High Court, because they are the ones who are capable of striking down something or reading down something or in the country. So I believe that you must give it a try for the entire period and leave it to the High Court to decide whether they will restrict it to 2 years or more than 2 years.
Thank you, sir. So the next question is by Mr. Ganesh Andage. He asked whether the ratio in the decision in Bhai Mamubhai Trust by Honorable Bombay High Court can be applied in the case of a notice period, amount paid by employee to employer liable for payment of service tax.
You see, the Madras High Court in one of the decisions has already held this notice period cannot be bought to tax under the service tax regime under the declared services. The same concept comes in Schedule 2 in our GST law. So in my view, you don't need to apply that case law at all. You can simply say that in a notice period, there is no service being rendered. There is no supply of services. There is no value addition being rendered. There is also decision of the European Court of Justice in these cases, where they have specifically said if there is no supply, negative supplies cannot be brought to tax. So there are several decisions. I think you can rely on these decisions. HND, some case, Madras High Court, single judge held so.
Thank you, sir. Next question is by Sai Prasad sir again. He asked whether is ITC a vested right or a concession? Different courts have given different views. What is your view?
My view as far as ITC under the GST Act is concerned is because of the constitutional objective. See, earlier, if you see, prior to the Constitutional Amendment Bill, it was a legislative device by which input tax credit was given. And therefore, the courts probably in Jayam and Company and so many other decisions held that it is a concession. In my view, even that was not completely correct because it is a right given and it's vests in you. Because the decisions Naishar Motors and Daiichi Karkaria, in my view, were better decisions than Jayam and Company. And the facts were different. But when it comes to GST law, the constitutional, when they passed the Amendment Act, the Amendment Bill says, we are introducing GST so that cascading effect of taxes will be taken out. There will be seamless flow of credit. That is a constitutional objective. No more you can say it is a concession given by a legislature. It's a constitutional objective. So in my view, credit has to be given.
The next question is by Sahil Tharani. He asked, Senvat credit availed during excise. The inputs being written off, but inputs are available in factory. Do GST reversal trigger? If yes, on what value?
No. See, the tax liability under the old law will go under the old law. It cannot be carried forward into the GST regime by virtue of Section 174 of the
So the next question is by Vinaya Hegde. They ask, now the refund is restricted only to the extent of invoices uploaded in GSTR 2A.
Strike down that rule, sir. 36 bracket 4 you are saying that you are restricting it to 10%, 20% businesses, sir. That is precisely the writ petition I have filed in Karnataka High Court and it has been admitted for final hearing. So you must challenge these restrictions that are being made. In my view, the fault of the supplier cannot extend to the buyer. There is no such. You cannot do it. It is unreasonable because as far as I am concerned, I have paid the taxes, I have taken the goods, I have used the goods. You can't, through a rule, put this kind of a restriction. If you look at it that way, there is a decision of the Delhi High Court, the VAT on Quest Manufacturing. And there's another decision in Tata Motors case. You see these two decisions, they say non-payment of taxes by the supplier cannot lead to you losing the credit. What can you do? So in my view, you should challenge that.
So the next question is by Mr. Rangaswamy. What is the position regarding taking ITC on CVD and SAD paid in GST period towards non-fulfillment of export obligation?
Yes. In my view, sir, it is a very unfortunate provision for which you have no choice but to move to the High Court. Because you will be paying the CVD and the SAD as per the old law. And you will not be able to take the credit under the new law because that is not a specified duty under the new law. So you are in a catch-22 position, which probably the legislature has not foreseen. So in my view, you must go to the High Court against these cases.
So the next question is by Mr. Jaibullah. He asked, upon detention of a vehicle, can proper officer reject the ownership of goods and levy tax and penalty under section 129 subsection 1 clause B without considering 129 1A?
In my view, I've told you, 129 has to be read down completely. It is only those transit offenses which can be brought. Not all these kind of offenses. You are not owner, I am not owner. I mean, different, what you said. You have different provisions. If you're owner, you come forward as owner or you don't come forward as owner. You cannot reject that. The officer is not vested with the power to say, I don't consider you as owner if you come forward as owner. He can't do that. My view, he can't do that. He cannot decide a title dispute in the garb of 129 of the Act. It's not permitted.
So the next question is by whether retrospective amendment incorporating the term within such time to overcome High Court decisions correct in view of Hayden's rule or mischief rule. If retrospective amendment can be assailed, then on what grounds?
Yeah. See, retrospective amendments can be made by the legislature. The question is, power of retrospective amendment is vested in legislature, they can do it. Nothing can stop them. But what can stop them is whether it's reasonable or unreasonable. That can be challenged. So the only ground on which you can challenge it is whether it is unreasonable or unreasonable. That has to be tested in court of law. In my view, they're putting a time period within which it can be claimed as one of the, and doing it retrospectively, in my view, can certainly be challenged because you not having it and I having taken it, now you cannot say the original period should have been that. Now I am going to restrict you to this. You are going back in time and restricting the claims unreasonably. And I'm also sure that these transitional credits for which they have done, they have not answered the other question of the Delhi High Court. That question which the Delhi High Court posed is, you are only taking into account your system errors and not the human errors. That is a discrimination. That has not been addressed. So on both these grounds, I think it is I think transactional credits is a good case for.
So the next question is by Mr. Sriraj Ramachandran. He says, in the case of NVK Mohammed Sultan Dhavtar and Sons, the Kerala High Court decision held that the officer cannot detain goods based on classification issues.
Absolutely. Absolutely. Even in Synergy Patikam also, the Gujarat High Court said the same thing. It's a very good decision. This is what I told you. 129 says only during transit time. You cannot say, I believe classification should be so on, this one, that one. Those are not the grounds on which goods can be detained. It's a very good decision.
So the question is by Sunil. He asks that whether ITC on construction of building claimed and later Supreme Court disallows it, can we capitalize it with retrospective effect and claim depreciation? Say the decision comes after 3 to 4 years, or can it be claimed as an expenditure in the year of decision?
This is more an income tax question. Should have not been asked to me, but nevertheless, I will tell you. Every decision is retrospective in nature. The principle of decisions is it operates retrospectively. Supreme Court decision passed after 20 years applies retrospectively to that was the law. If that was interpreted wrongly by the High Court, that is actually the law. So it applies way back to 2017. So you can, based on the Supreme Court decision, capitalize it with retrospective effect. Only thing is there's a difficulty. You should look at your company law and other laws to say if the accounts are passed at AGM, assessments are done, how do you get over it? So that you will have to check with your auditors and see if that can be attempted. Otherwise, prospectively, you cannot claim it as you can claim it. If you're paying that amount completely, prospectively, that means you are not going to recover it from anyone. Correct? So there is no harm in you claiming it as an expenditure in the present circumstances because it is incurred in the course of business.
So there are multiple other questions which have been asked, but I think due to the paucity of time, we may not be able to take it up. Time permits, we will share the questions with you, and if you can share the answers to us, it would be really helpful, sir. And one more demand that we have got from most of the participants is it possible to share the list of case laws that have been referred during the course of
No problem. I will send the PowerPoint itself to the KCA. I'll send it to you. You share it with all the participants.
Thank you, sir. Now I hand over the proceedings to Prabhava for a formal vote of thanks.
Big thank you to my colleague CA Mukul Sringeri for the moderation. There are no words to express our gratitude to our dear speaker V. Raghuraman sir for overcoming the physical barrier and finding time in your busy schedule to make this event successful. The insights which you gave us in this webinar was simply tremendous, and I am sure we had a lot of aspects cleared. Once again, thank you a lot, sir.
Thank you very much. It's my pleasure. I am among my brother and my sisters, so it's my duty to clarify to the best of my ability. I have to thank the KSCA because they are on the forefront of these kind of activities of spreading and disseminating information. So we consider it as a duty, sir.
Thank you, sir. Thank you a lot.
Thank you very much.
I also extend my thanks to KSCAA and the event organizers for their enormous cooperation in the organization of this event. I thank our beloved President, CA Chandrasekhar Shetty, our technical team members without whom the program could not have been successful, CA Vijay Kumar Patel and CA Vinayak Bhatt, and not to forget CA Ganesh V. Shandage, Chairman of Indirect Tax Committee of KSCAA. Thanks a lot, sir. Last but not the least, I would like to take this opportunity to place on record our hearty thanks to all the viewers for attending this webinar and making it a big success. This seminar is attended by around 300 members consistently, which I would say is a gigantic response in terms of attendance. Thank you all for this. This gives us a lot of strength and push for our further programs. We hope you achieved what you came here to achieve. Any feedbacks can be provided, which will be looked into in the coming seminars. Please note that the presentation and the video of the webinar will be hosted on the website of KSCAA in due course. The upcoming webinars from Indirect Taxation Committee are as follows. Webinar on different assessments under GST law by speaker Advocate CAA Sai Prasad, which is on Friday, this 21st August 2020. Time is from 11 a.m. to 1 p.m. One more seminar is on gaps in GST implementation with expectation of industry. The speaker will be CA Mandar Telang from Mumbai. It will be on 25th August 2020 on Tuesday. The time is from 4 p.m. to 6 p.m. The next third webinar in this month is on GST on immobile properties and liquidated damages. The speaker is Advocate Sujit Ghosh from New Delhi. It is on 29th August on Saturday. The timings will be 4 to 6 p.m. So with this, I myself, Prabhava Hegde from Indirect Tax Committee will be signing off. Goodbye. Bye-bye. Thank you.